go ahead and start.
Ready to start?
I'm running one short, yeah.
Okay, how y'all doing this morning?
Good.
Everybody doing good?
Yes, sir.
All right. I'm Dr. Tom Coates, for the ones of you that don't know me. Some of you I've seen before, had in class. So, Dr. Briggs asked me to come by and do a presentation talking about policy and procedures and legal issues as it relates to strength and conditioning facilities. Before I start, I need to get a feel for where you're going with this course. What do you want to do with this? Is this just a course you have to take, or is going into strength and conditioning, becoming a strength and conditioning coach, is that a direction that you want to go professionally? Where are you in terms of looking at relating this course to your future profession?
I'm thinking about going into actual college strength and conditioning coaching.
Okay, all right.
I would like to do it overseas.
Overseas strength and conditioning? Okay, be the same kind of thing, just a different location, yeah.
I'd like to be more of a cultural, but a lot of that could be like strength and conditioning.
Okay.
Yeah.
Okay.
Right now I'm just taking the course.
Not real sure where you're going with it, but hopefully it'll be useful.
Yes, the same with me.
Same with you? Okay, all right. The reason I need to ask that question is, and I kind of got the answer I thought I would get, a lot of you are interested in athletics, maybe going toward becoming a strength and conditioning coach. The facilities that you're going to be going into are probably already established, but again, you may go into a situation where you have an opportunity to actually develop a facility. When we talk about some of these things today, don't say to yourself, well, that's not where I want to be, that's not important to me, because I really believe that the material that I'm going to present to you has a lot of potential usefulness in the future. As a matter of fact, some of the things I'm going to talk about today may actually save your career. And you're going to say, well, I don't see the facility in this. Well, it's there. It's there. But these are underlying things that affect all of us in the profession, and it really affects you, and a lot of times I see it, and people don't even realize what they're doing correctly and what they're doing incorrectly. So when we go through some of this stuff and you say, well, I don't see how this relates to me, it does. Just go in it with an open mind and think, how can I use this, or how could I use this information as I move forward and going into strength and conditioning. And we're going to be talking about policies and procedures, and we're going to be talking about legal issues. Now, if you come in here this morning thinking in terms of, I want to give you a list of policies that you need to implement in your particular strength and conditioning program, you're not going to get that from me. You're going to have to develop your policies, and you're going to have to develop your procedures. I'll give you some information to try to help you understand policies and procedures, but the real hit is going to be on legal issues. And the reason for that is legal issues will be the underpinning element for the development of your policies and procedures. Anytime you have policies, why do you have those policies? When you develop procedures that line with the policies that you have, why do you do what you do in terms of those procedures? And it's going to relate back to risk that's associated with operating your facility. And that goes into risk management. And risk management ties in with legal and legal issues. So when I get off on the legal issues thing and start talking about that, don't tune me out and say, well, this doesn't matter because I'm not getting anything specific on policies. I don't see how this relates to strength and conditioning or strength and conditioning facilities. Gentlemen, it does. It does. So try to take this with an open mind and just think, how can I use this? Because this thing is real, and this could be one of the most important things you get outside of actually learning how to implement programs. So let's start off with this, policies and procedures. We hear these terms all the time, but what are policies and procedures? If you look at policies basically are courses of action selected based on given conditions to guide and determine decisions. Okay? So these are courses of action. By the way, I think Dr. Briggs is going to put these PowerPoints up for you. So take some notes, but again, he'll put these up for you as well. So those are the policies that we're talking about. You're going to develop policies. For example, you're sitting around in here now, I see you, tell me what is the major policy that you're dealing with here at North Greenville University right now, and have been dealing with for a year? COVID-19. Okay, it's across the country. This is an easy one, guys. So we're dealing with COVID-19. So what's the issue? COVID-19 and the health of individuals, right? So we need to develop a policy related to that. So the university's basically said, look, what we're going to do here at North Greenville University is we're going to implement the CDC guidelines to protect individuals from COVID-19. That's a policy that the university has, okay? Now, the next question is, how do you implement that? That's where the procedures come in. The procedures, particular prescribed manners or methods of proceeding in a process or a course of action. So the policy becomes a course of action. Procedures become how we're going to implement that. For example, the university says we're going to implement CDC policy on this. Okay, good. That becomes a policy of the university. So how do we do that? You're wearing masks. We talk about social distancing. We reduce the size of classes. We go online. All of those become procedures that help implement that policy. So when you're talking about strength and conditioning facilities and you have policies, why do you have those policies and what issues do those policies address? And then the next thing is, how do you implement those policies? For example, you may say that it's a policy of this facility to employ individuals that are adequately trained and prepared to serve as personal trainers. That becomes a policy that you have. So if I walk in your facility and someone comes up and they're a personal trainer, I know that that person, according to your policy, that individual is trained and prepared to be a personal trainer. But how do you ensure that? Do you check their credentials? Do you check their educational background? Do you check their certification? Do you provide additional training for them? How do you implement that policy? So those become your policies and procedures. So there's the policy and procedures part. I didn't give you any policies, I didn't give you any procedures, but I tried to explain the difference in policies and procedures. You'll have to develop your policies. You'll have to develop the procedures within your facility. Some of those will already be in place. Some of the policies that you will be dealing with will be more or less dictated by professional standards. We'll get to that in just a little bit. So if we look at the legal issues, and the other point I want to bring into this is risk management, because risk management is something that ties in, you need to be aware of. I would venture to say that as you move forward as a professional and you graduate and you go on and you get that job working in the strength and conditioning environment, whether it be at a college or university level as a strength coach or in a private gym as a personal trainer or whatever, if you ask them if they've ever done a risk management assessment, if they have a risk management plan, I'm sorry to say that probably most of them would say no, because they don't see the need in it, because they don't understand what it is and how it can help them. So if we look at this thing, we look at legal issues and risk management. When we talk about legal, it's conforming to or permitted by law or established rules. A lot of times when we think about legal, we only think about the law, but we don't think about other rules or regulations that also carry the same weight as law. And you're still responsible for those. So when we talk about legal, we're talking about the law and what the law says is correct and what the law allows and what the law says is not acceptable in society and what law doesn't allow. But also we consider other rules and regulations that are established by governmental bodies that will affect us. For example, if you're working in the fitness industry and you're working in a gym, private gym, you're going to have regulations that deal with safety and health. And those regulations are going to be dictated to you by the local government, the state government, the federal government. It's not like, oh, this law says this. No, these are regulations that have been established by governmental agencies. and they carry the same weight as the law, and you're still gonna be responsible for those. So that's the law part. Now, here's risk management. Now, the definition for this is a little more lengthy. We dig into it a little bit. Risk management. There's a lot of meat here. Risk management is an integrated strategy for both conducting safe, equitable programs and reducing the potential for loss arising from successful legal claims against the program, its individual employees, and administration. Now that covers a lot of territory. And this risk management thing, usually when we think back, let me ask you this question. When you think about risk management, and you're thinking in terms of a strength and conditioning facility, what risk do you have? What risks are there?
Injury
Injury to who?
to the people or the participants, like players.
Okay, that's usually the first thing that happens. You think in terms of the clients or the individuals that you serve and risk management as it relates to those individuals. Let me ask you this question. What about your employees? Are there risks associated for your employees? Does risk management include your employees?
It should.
Yes, it should. So most people think in terms of just the individuals you serve, but it's much, much more than that. What about the financial risk to your organization? What happens if you have a machine that breaks down? It's no longer in service. What happens?
You have to close it off.
You have to close it off. If you close it off, what does that mean?
Nobody can use it.
Nobody can use it. So your clients will no longer have access to that particular piece of equipment. Are you making money or losing money at that point?
Losing.
You could be losing money. Someone may say, well, you know, you've only got 3 recumbent bikes, and I really enjoy using the recumbent bike because I like to do cardio in a reclining position. And they come in there, and there's one down, there's only 2 left, and there's people lined up trying to get on those 2. They might just say, I'm no longer going to come to this gym, I'm going to go to the other gym because their equipment is better, it's serviceable, it's usable, and on top of that, they have more than you do. You just lost a client. And then you have word of mouth, and you know somebody else decides they're not going to come, yada, yada, yada. It can have potential impact. The other thing is the cost of repairing that piece of equipment. So you need to have a plan in place for how you deal with repairing equipment. That becomes part of risk management. How many of you have a car? How many of you have insurance on that? Why do you have insurance on your car?
In case something happens.
In case something happens. Okay? And because it's a state requirement. Okay? What does that do for you? What does that insurance do?
Makes it cheaper or nothing when you get to an accident, it protects you.
That's what you think, okay? And you're right. But here's the key to the whole thing. By having insurance and paying that premium, you are shifting part of the financial responsibility that is covered in your policy, you're shifting it from you to the insurance company. What the insurance company is saying is that we will pay X amount under these circumstances if you have an accident. You're shifting that responsibility. And they say to you, for a premium, for a certain amount of month, or a certain amount of money per year, we will accept that responsibility. Okay? What happens to your premiums if you have an accident?
They go up.
Why do they go up?
Because they don't think that you're responsible enough to handle a car well, and it may cost them more money.
That's good. But let's get down to the brass tacks here. Let's get down to the bottom line. Why are they going to raise your premium?
Make more money.
Yeah, make more money because they just lost money on you. They had to pay out on you. So, hey, if we're having to pay out on you, we're going to raise your premium so we can start making that back. Something to remember, guys. You're young now, you're going to grow older. It's going to be true today and tomorrow and the next day. Insurance companies are not in the business to lose money. Occasionally they will, but they're not in the business to lose money. So what they do is they raise those premiums, okay? So That's what we're looking at here. So that piece of equipment that you have, if you don't take care of it and it breaks down, it's gonna cost you money on that. So, policies, procedures, legal issues, risk management. So that's kind of the basic concept we want to run with here. We're not going to dig into any of those too deeply today because I want to hit some very important points here for you to consider. Let me ask you this question. What are some potential issues that you see that could be a problem for you working in the sport or strength and conditioning industry as a professional? What are some issues that you see that could be a problem for you?
Oversees the lack of proper equipment and regulations.
Proper equipment, rules and regulations, making sure that you're in compliance with those. What are some other?
There aren't really any.
There's standards out there.
There are standards, but for like overseas American football, there really aren't. So that's like a problem.
True. Now, if you go overseas, you're changing the dynamic of this conversation somewhat because you're going to be dealing with different types of legal systems. And I'll talk about this in terms of the American legal system, what we deal with here. But you go to a foreign country, you're going to be dealing with their particular legal system, which may have different parameters in terms of some of these terms we're looking at. Okay, so that's a good point. You're like that student I had in class one time that was from Canada. Man, we're just cooking and going along with all this discussion and everything. Student raises his hand and says, Dr. Coates, when are you going to discuss the legal system in Canada? I've got one student in the class from Canada. He wants to discuss the legal system from Canada. I said, we're not. We're going to discuss the legal system in the United States because right now that's where you are. Now, you go back to Canada, you take this information and you figure out what Canada says about it. Okay, good point. What are some other issues that you could face? What are some things that you're going to have to deal with in this particular profession?
Customer complaints, stuff like that, with
Okay.
like malfunctioning equipment.
Good. Customer service. Okay, a lot of implications here. Have you guys had a marketing class? Not yet? You will? Okay.
Some
Yeah.
of us do.
So you get into that marketing issue, all right, that you have customer service, there's implications there, okay? What are some other issues? Can you think of anything else? Let me throw out some here, okay? These are some things that off the top of my head I'm thinking, okay, what are these people in this class going to be dealing with here? Here's some of the things. Purpose of the facility. Purpose of, what the heck is he talking about? Purpose of facility there. What is the purpose of your facility? Some of you are interested in working with athletics. You're going to be a strength coach for an athletic team or teams. What's the purpose of your facility? To train the athletes. Do you work with anyone else? No, we don't work with the student body. We don't work with anyone from outside. We don't work with faculty and staff. All we work with are the athletes. Okay, there's your purpose. Do you work with male and female? That's your purpose. If you are in the private sector and you have your own gym or working at a private gym, what's your purpose? Your purpose is going to be to serve the general public. Male, female, young, old, healthy, unhealthy, physically fit, individuals with disabilities. It changes, the purpose changes. So one of the things you're going to be dealing with is the purpose of your facility. Exactly why do you exist as a facility? Now that's going to say a lot about your policies and procedures. It's also going to have implications relative to legal issues, potential legal issues that you could face. Here's another one, clients served. Who are you serving? What are you, what is the designated population or populations you want to serve? Again, that has some issues for you. Another one is the size of the operation. Couple of things here. What do you think I mean by size of the organization or operation? What do you think I mean by that? When I say size of?
First off, the size of your actual facilities, but also how big your staff is, and also how big your...
You got them both. You got them both. Two things you can look at there. Number one is the actual square footage, the size of your facility, and with the size of that facility, you're gonna have organizational issues within that facility. Okay, so that's gonna be an issue. The second thing is size in terms of the number of employees that you have. Okay, if it's just you, that's it. If you hire someone else, that starts to change the dynamics of the operation. If you hire multiple people, if you have assistant managers, that changes the dynamics. And all of these have implications for you in terms of legal issues that can arise and in terms of the policies and procedures that you set in place. Potential risk. We're going to talk a little bit more about risk management in just a little bit here, but what risks are involved? If we talk about risk, you say, oh, well, someone could be injured here, yada, 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 that's about it. No, you really take a hard, deep look at potential risk within the operation itself. Everything that you could possibly think of that would provide or create a risk for your operation. Everything. If you don't, then you ignore some of those potential risks there and you cannot be prepared to deal with them. In a proactive way, at least. You may be reactive, but that's not where you want to be. There may be other issues. These are just some that came to mind when I'm thinking about this, but there's other issues that come in there that you're going to be dealing with on this. So go into this thing with an open mind. Think in terms of issues that will affect the operation of the facility and how you can be prepared to deal with it. What do you think would be the number one legal issue that you would have to deal with in terms of a strength and conditioning facility operation? Have you had the legal class yet? Yeah. What would be the number one issue that you'd have to deal with?
Equipment malfunction? Or
Could-
like the improper use of the equipment?
That's, you're there, but what would we call that?
Off premise? No.
And you're close, you're getting close. So let me just give it to you. You're so close on that, just let me give it to you. Have any of you ever heard of this? Negligence. Negligence. Now, if you don't get anything else today, get the negligence piece, okay? Negligence. Negligence is probably going to be the number one issue that you're going to deal with. Malfunctioning equipment. You're operating a facility. A piece of equipment malfunctions. Someone is injured. Whose responsibility is it? Well, it's not mine, but you're the manager, you're the owner, you're the operator of the facility. Well, it's not my responsibility. I couldn't help if that piece of equipment didn't operate properly. Someone said, it wasn't my fault. Well, whose fault is it? Did you maintain it? Have you maintained it properly? Yeah, I think we've been keeping up with it. Show me your records. Show me your maintenance records on that particular piece of equipment. Show me the manufacturer's maintenance requirements for that piece of equipment. I don't have that. You should. Guess what? Someone's building a case against you right now for negligence. If you can't prove that you maintain that piece of equipment properly, if you can't prove that if it was repairs were made, if they were not made by someone who is certified, trained, authorized to make those types of repairs, you're negligent. And you never think about that. It gets down to that point, guys. It gets down to that point. So negligence is this issue that we deal with, and this is the thing that's going to slip up behind you and it's going to bite you. And when it bites, it can really hurt. So, how do we define negligence? This is a definition. Ooh, look at my spacing on that, Dr. Briggs. Thought I had all these spacing issues straightened out on this thing. This comes from Black's Law Dictionary. There's several law dictionaries out there, legal dictionaries out there. to help people understand legal terms. This is one, comes from Black's Law Dictionary. Black's Law Dictionary is kind of the gold standard for defining legal terms. This is wordy, I know, but let's go through this. You need to understand what negligence is. Negligence is the omission to do something which a reasonable person, guided by those ordinary considerations, which ordinarily regulate human affairs, would do, or to do something which a reasonable and prudent person would not do. Now look at that, read it, and tell me what it means. I don't care if you memorize it, if you don't know what it means, it has no value. So what does it mean?
The failure to do something, properly, or yeah. Or the failure
Okay.
to do something without considering like what are the everyday, ordinary things, what we do, or
Okay,
how we handle things.
you got it. You got the first part, omission. You said to do. If you don't do what you should do, what would be expected of you, then you can be negligent. There's another piece to this. What's the other piece?
Doing something that a normal person and reasonable person wouldn't do.
That's it. Something that a reasonable person would not do under the circumstances can also be considered negligence. We refer to this as acts of omission and commission. Omitting is not doing something that a reasonably prudent person would be expected to do under the circumstances. Commission is the committing of an act that a reasonably prudent person would not be expected to do under the circumstances. Now, the real bug in this thing, you can look at this and say, wow, that's pretty cool. We know exactly what, excuse me, know what negligence is. But it's not that black and white. It's gray. Because there's part of this definition that is open for interpretation. There's actually more than that, but there's one major piece that's open for interpretation. What is that major piece in this definition that's open for interpretation?
Who an ordinary person is and what ordinarily they would do.
Yes, that's exactly it. How do you define a reasonably prudent person under a specific set of circumstances? That's the piece right there. Did you act as a reasonably prudent person should have acted under these particular circumstances? Who makes that decision? Whether or not you did or didn't do what you should have done? Where is that decision made?
The prosecutor, or in the board?
The judge probably.
You guys are close. In the courts. In the courts. Judge looks at that. He hears testimony from the plaintiff's side, testimony from the defendant's side, and the decision is made. Did you act as a reasonably prudent person would under the circumstances? Judge, jury, that's how that decision is made. Now again, there's nothing there that says this is exactly what a reasonably prudent person looks like. It's what does the judge, what does the jury think a reasonably prudent person would do or should do under those circumstances? What does this have to do with policies and procedures and legal issues as it relates to operation of a strength and conditioning facility? Everything. Because you're there and you're in a position of responsibility. You may be the manager. You may be one of the strength coaches. Did you do what a reasonably prudent person would be expected to do under those circumstances? Something goes wrong, someone brings legal action, that's where we are. So you need to understand this because this is very, very serious. I saw a piece in the paper this morning. I always look to see what's going on in Florence, Alabama. We spent 10 years down there, great place. But I always look to see because I still have a lot of friends down there and just want to see what's going on. saw a piece in the paper this morning. Gentleman took 6 years, I think it was 6 years to resolve this issue. The price tag on it, $1.75 million. $1.75 million. These lawsuits can go for millions of dollars. That's not counting your cost on this. Okay, let's move on from this one. There are 4 elements of negligence, and I'm giving you these to try to help you understand what negligence is. First of all, a legal duty of care. The legal duty of care is a duty or obligation recognized by the law requiring the defendant to conform to certain standards of care to protect others against unreasonable risk. That is a legal duty of care, obligated by law on the part of the defendant. Now, we have by the way, these are civil cases. We're not going to go into criminal. If you get into criminal, you've got some bigger issues than this, okay? We're just going to deal with civil on this. We have a defendant and a plaintiff. Who is the plaintiff and who is the defendant? Who's the plaintiff and who's the defendant?
Plaintiff is the person that is accusing, and then the plaintiff is the person being accused.
You got it. The plaintiff is the individual who is injured, has alleged injury, and the defendant is the one who the plaintiff alleged caused their injury. So on the part of the defendant, you're going to be obligated by law to do certain things, to conform to certain standards, to protect individuals from what kind of risk?
Unreasonable.
Unreasonable risk. So there's unreasonable risk, but there's also inherent risk. Are there inherent risks associated with strength and conditioning training?
Oh, for sure.
Yes, there are. Well, where do you draw the line between unreasonable risk and reasonable risk? Where do you draw the line?
I mean, I would say it's whether the equipment would have worked properly if the individual had followed instructions.
The equipment. Now, you got another piece in there you kind of slid in right at the very end, but what else? You said if the individual did what?
Follows proper instruction.
So the second piece of that is, what was the instruction given? What if the instruction that was given was incorrect?
Then it's on you.
It's on you.
Policies are wrong.
See, there you go. See how this thing ties together on this? Now, I'm going to ask you this question. Have you had any experience so far in your life that raises the expectation of you providing a legal duty of care to individuals in a strength conditioning situation? You're just a college student. You haven't graduated yet. But have you had any experiences in your life to date that raises this level of expectation on your part? Have any of you ever worked in a strength and conditioning setting?
Not as an employee or as a coach, but as an athlete.
Okay, so you should know something about it, shouldn't you? Maybe not as much as you should know, because what you receive is information from your strength coach or your coach. Did they know what they were talking about? You assume that they did, but that's not always true. Wish it was, but the reality is that it's not. Anything else? Any other experiences? Did any of you have any certifications related to strength and conditioning?
CQRA.
Okay, so you have that. What's the date on yours?
I got 2 or 3 months left. It's in the expired in June.
Yep. Yep. It's coming up. 2 years. 2 years. Okay. Let me throw one other thing out to you. You're gonna finish this class, and you're gonna pass this class. You'll get a grade. Dr. Briggs, watch my time for me and kind of give me a signal back there, because I'll just keep going. You're going to finish this class, you're going to get a passing grade in it, and it's going to go on your transcript, and you're going to go on and you'll meet the rest of your requirements for graduation, you'll graduate with your degree in sport management, you go out in the world, do whatever you're gonna do, and perhaps you'll be working in strength and conditioning environments, okay? Something happens, and you become the defendant in a negligence lawsuit. And the plaintiff claims that you've done something or hadn't done something that you should have done that's resulted in injury to them. Their attorney is gonna try to find everything that they can, they're gonna dig up every bit of information that they can on you to determine whether or not you did what you were supposed to do. And they're gonna look at your college transcript. What's your degree? Sport management. What is sport management? Let's take a look at the courses that you had at North Greenville University. Oh, wait a minute. I see here that you had a course in strength and conditioning. Really? What did you learn in that course? Oh, let's go back, look at a copy of the course syllabus to see what that course syllabus says, because that course syllabus outlines what was supposed to be covered in the course. Oh, really? So you should know these things. You had this course. You got to be in this class. And yet here you are out here working in the profession, and you just did something, allegedly, that resulted in injury to someone. Gentlemen, what I'm saying to you is you sit in this classroom in this course, you are raising the expectation that you know, or should have known, what to do in a situation dealing with strength and conditioning. You just raised the standard. Most people don't think of it that way. I'll get through that course, I'll get my grade, I'll forget about that class, sell my book, throw my notes away, go on life's grade. And it comes back and bites you. So you're raised by sitting in this classroom, taking this class, going on your transcript, getting a passing grade, you are raising the expectation that you know what you're doing. Certification, CPR, first aid. Let me give you a little hint about certification. Interesting thing, we put a lot of weight on certification. Let me tell you what certification really means. You get a card that says that you're certified in CPR, first aid, whatever. All that card means is that at a particular time and date, you are able to demonstrate knowledge of and performance of certain skills to an individual that was qualified, authorized, certified to say that you knew what you were doing. On that date, you could do that. That certification is good for 2 years. Can you still effectively perform CPR 2 years from the date that you were certified? Does that certificate say that you can? That certificate says that on the date we tested you, you could. But you haven't done anything since then. You haven't practiced, you haven't had any additional training. Yet 2 years from now, certification's still good. The expectation is that you know how to do it. You may or you may not. So that raises the issue of continuous training. All right, see how this thing is? We got you already, guys. We've already got you on this thing. The second thing is, the first one is the legal duty of care, okay? If there's no legal duty of care, we can't have negligence. Well, if we can prove that there's a legal duty of care, we got you. The second thing is a breach of that legal duty. And this is where the failure to conform to the standards comes in. This is when you either not do what you were supposed to do, or do something you shouldn't have done. You breach those duties, that duty of care. And if we can prove that, we got you. The third one is we have to link that breach of duty with the actual fourth part, which is injury. We have to link the two together. Is there a relationship between that breach of duty that we've been able to establish and the actual injury that resulted to the plaintiff? And this is called causation. A reasonable connection between the conduct of the defendant and resulting injury or loss to the plaintiff. And this can come in either one of two ways. One is cause and effect, where the actual, the action on the part of the defendant is linked directly to the injury to the plaintiff. And the second one is a proximate cause, where there is sufficient close relationship between the action on the part of the defendant and the injury to the plaintiff. If we can establish that causation, we can link the two, and there's only one other piece left, and that's injury. If there was injury to the plaintiff, then we got it. We've got all four parts of negligence. You have to have all four in order to establish negligence. So if you're the defendant and the plaintiff has alleged that you've done something that's resulted in injury and you have a negligence lawsuit, these are the parts that the plaintiff's attorney is going to be looking for. Now take that back to working in a strength and conditioning facility. Someone's injured in your facility. Do you have a legal duty of care? Yeah, I'm there, I'm the boss. I have a contract with this individual. We'll talk about contracts later if we have time. So you have a legal duty of care? Yeah. Did you breach that duty? Did you not do something that you should have done? Did you do something you should have done? Okay, and then the next thing is causation. Can we link that breach to the actual injury, and then what did injury occur? There it is. You guys are going to step right into that. You're going to step right into that. So the first thing you need to look at is that legal duty of care. You need to understand that you have a legal duty of care. And from that, protect yourself as best you can. Risk management, let me give you a definition for risk management here. Risk management is important, and I would encourage you to look at developing a risk management plan for your organization, and you can use this for a couple of different things, actually more than that. But one of the things that you can use it for is to protect yourself or try to plan, be proactive to deal with any risk associated with your operation. The second thing for risk management is you can use this when you're getting insurance, liability insurance. If you have a risk management plan, insurance companies will look at that and say, okay, you're planning on being proactive, so we can give you a better rate, charge you less in terms of the premiums for your liability insurance, because you are planning to deal with this situation beforehand. Proactive as opposed to being reacting after something happens. Risk management, an integrated strategy for both conducting safe, equitable programs and reducing the potential for loss arising from successful legal claims against the program, its individual employees, and administration. So there we are. In terms of looking at risk management, you have what's called the risk management cycle. There are four parts to this. One is risk identification. You take a good, close, hard look at your entire operation and see what risks are there. Everything that you can find that's a potential risk. List them all. Look at every aspect. Find everything that could be a risk. This takes time. And you may see something, well, you know, something could happen here, but the chances are slim to none that it'll happen. We're not going to include that. You're not going to have a good risk management plan. You're going to leave something out. Everything goes in there. Second thing is risk evaluation. There are two things you look at on risk evaluation. One is the frequency that risk may occur, and two is the severity of the risk when it occurs. And you make decisions on that. Is it, you know, you're going to get a little skin knuckle. Okay, how often is that going to happen? Well, that may happen every few weeks or something. How severe is it? That's not very severe. It's not life-threatening. So, okay, we can deal with that. Okay? But let me ask you this. I'm going to get out of the gym for a minute and get to the pool. How many drownings can you afford to have in your pool?
None.
None. None. Zero. Why?
Only takes one to shut you down.
It takes one to shut you down. It is severe because we're dealing with the loss of life. That is unacceptable. So if you're looking at the severity of a drowning in the pool is extremely high. Frequency is very low. So if you're working, has any of you ever worked at a pool? Yeah. So what do you do to prevent drownings?
Active scanning, gotta make sure you have lifeguards
you go. You do everything you can to prevent that, okay? Everything you can to prevent it. Now, if you've done everything that you can, everything that a reasonably prudent person would do, and a drowning occurs, it happened. Sorry. But we had done everything that we possibly could do on this. So when you look at risk management, the severity and the frequency have to be taken into consideration when you're looking at evaluating risk. So you have to take a look at this. The second one is risk treatment. Risk treatment deals with what you're going to do with those risks. Are you going to accept those risks? That little skin knuckle? We don't want that to happen, but it's not a big deal if it does. Okay? So we can accept that. Okay? But on the other end of the spectrum, something that threatens life and limb, we can't accept that. So you make a decision how you're going to deal with those risks. On that, policy procedures come into play again right there. And then the last piece of this is you develop a risk management plan to deal with all the risks that you've identified. And you have this risk management plan in place, and you implement that risk management plan. Okay? You're working in a strength and conditioning facility. An employee notices that there is water on the floor. Someone came in with their water bottle, they dropped it, there's water on the floor. What do they do? The employees coming through and they notice you've got water on the floor here, coming into the lobby. What do?
They should dry it up and put a slippery one that time,
Why should they do that?
because that way they're covering their own tail and making sure that employee or clients don't step on it.
But that, I'm just an employee. I've only been working here for a week. I'm not in charge of anything. Why don't I report that to the manager of the facility?
Because if you don't, I'll fire you.
Yeah, maybe. That's another way of looking at it. Why not, okay, gee whiz, there's water on the floor here. Yeah, Anna, it could be a problem, but I don't know what to do. I'm gonna go to the manager, I'm gonna ask the manager, hey, what do I do? There's water on the floor out there in the lobby.
Or you should have a plan for it, a management plan.
Really? So, does that relate back to policies and procedures? Something like a wet place on the floor, you're exactly right. You see it, dry it up, clean it up, put it aside. Don't take it to the management. That's something you can do. You notice that there's a problem with one of the machines. What do you do in that situation?
Tell somebody.
Are you qualified to fix it? Do you know how to fix it? You're not. That's an issue that goes higher. So what's your policy and procedures for dealing with that? You see how all this stuff ties together? Don't take these classes that you're taking and isolate the content of those classes and go through the classes and say, okay, yeah, I got this. I'm going to study, pass the test, get my grade, go on, life's good. No, guys, these things, all this stuff that you're getting in your classes, it all ties together. And in your mind, you need to be thinking about, how does this relate to what I've learned in another class or what's coming to me in another class? If you've had legal issues, this should not be something that is totally new to you. We may have to refresh your memory on some of this, but it shouldn't be totally new. So when you look at this, we get into these things. 5 minutes. Let's look at the plaintiff versus the defendant. First of all, I kind of mentioned this. What we're looking at is a tort. Legally, it's referred to as a tort. It's a civil claim, not a criminal claim. It's a civil claim in which one party alleges the action or inaction of another party resulted in damage for which compensation is requested. What compensation? Define compensation for me. You're injured. What's compensation? What do you want for your injury?
Bills paid, your hospital bills, or just some sort of money.
Money. You want money. I want money for my injuries, to compensate me for my injuries. I want money to pay my bills. I want money to compensate me for lost wages. I want money to compensate me for future lost income. money. You've got a broken arm, we can't do anything to go back and change the fact that you've got a broken arm. You will go through the rest of your life with the signs of a broken arm. You have to x-ray to find it, but it'll be there. Nothing is going to change that. The only thing that we can do is come up with some way of compensating you for your pain and suffering, and the only way we can do that is money. So that's what we're looking at here. No one's going to jail. This is civil. This is not criminal. So what we're looking at is that compensation for money. Why do you have automobile insurance? Why do you have automobile insurance?
It shifts the monetary responsibility onto the insurance company in case you get in a wreck.
Part of it. Could be all of it, could be part of it. But what do you do to get that shift of financial responsibility?
You pay for it.
You pay for it in terms of a premium. See how this whole thing works? Okay? On that. It's a, when we look at this, a negligence, it's civil as opposed to criminal in nature. What are the responsibilities or some of the responsibilities of the defendant? The defendant is the one who is accused or alleged that has done something that they shouldn't do. One, provide a safe environment. Think of this. You're responsible for a strength and conditioning facility. It's going to be expected that that environment is safe. And you can dig as deep as you want to go on that safe environment. But it's expected that the environment is safe. Someone comes to you. It comes in your facility. They can reasonably expect that it's going to be a safe environment. That athlete comes to you and for working out, and you're the strength and conditioning coach for a team. They come to the weight room. They can reasonably expect that it is a safe environment. Do they know all the ins and outs of what makes a safe environment? Probably not, but it can be expected that it is safe. Okay? It can be, there's a responsibility to conform to industry standards. And a lot of people will set up facilities, run facilities. They have no idea what industry standards are. I'll guarantee you, if you go to court on this, the plaintiff's attorney is going to dig deep and they're going to come up with industry standards, and you're going to get hit with those. And be questioned about it. Do you conform to these standards? Did you do this? Did you do this? It's going to be there. Another expectation is providing proper instructions. How do you do a certain kind of lift? How do you use this particular piece of equipment? What's the proper way of doing it? Not the way you do it or the way you think it should be done, but how does the industry say it should be done? What is the proper way to do it? Providing instruction. Another aspect of this is to conform to contractual agreements. If you have contracts with individuals, customers that are coming in, these are not your athletes, but individuals that are coming into your center, you have a contract with them, you're expected to conform to that contractual agreement. What did the parties agree to? What do they expect from you? What did you say that you would provide? These are some of the responsibilities of the defendant. What about the plaintiff? Responsible for self. They're responsible for themselves. Follow instruction. Use reasonable care on their part. That's what they're responsible for. Some important legal doctrines that you might want to consider here, and there's some different terms for this, but I'm going to keep it simple. There we have what's called contributory negligence and comparative negligence. What this deals with in a negligence lawsuit, this is something that the defendant can use to protect themselves or help build their case against the plaintiff. Contributory negligence, comparative negligence deals with negligence that occurred on the part of the plaintiff. If the plaintiff did something that he or she should not have done, something that he or she did that a reasonable person would not be expected to do, then they contributed to their own injury, and this can impact the decision of the court relative to damages awarded to the plaintiff. Another one is ultra-virus work versus respondent superior. Take particular note on this one. Respondent superior is when you are a subordinate employee. You are working for a manager of a facility. You are an assistant under the head strength coach. And that person in a superior position tells you, gives you directions to do something. And you follow those directions. And as a result of your action of following the directions given to you by your superior, injury occurs. You can use that as a possible defense to protect yourself and shift the responsibility back to your superior. Okay? So you guys need to remember that, because you may not go in as the head dog on this thing. You may simply go in as that assistant, that employee, and the boss says to do this, and you do what you're told and someone is injured, you're going to be sued. But you can protect yourself by saying, I was only following the directions, the orders that I was given by my superior. Now, the other side of that coin is ultra-virus. This is when you have an individual in a subordinate position that goes beyond his or her assigned duties or areas of responsibility. They take on duties that they are not responsible for. For example, you're working in a facility, strength and conditioning facility, and your job, since you're a newbie, you just got there, you've been working there for a week, and your responsibility is to make sure that the free weights are all racked up, that the area is cleaned, that all the equipment is disinfected. That's your job. That is your job. Keep the place picked up, keep the weights all racked up, make sure that everything is wiped down, sanitized. That's your job. But you're in the process of doing your job here, and someone comes up and says, hey, will you show me how to do this particular lift with these free weights? And you think, well, I do that. Okay, yeah, I'll help you with that. So you go over and you help this individual. You show them, this is how I do it, yada, yada, yada. The individual does the lift, whatever, and they hurt their back. And they decide they're going to sue. Well, they're going to sue you. Yeah, but how much money do you have? They're not going to get $1 million out of you. You don't have liability insurance. They're going to the deep pockets, so they're going to hit the manager, they're going to hit the company, whatever, okay? So rather than them putting out the money and accepting responsibility for this, what they're going to do is they're going to shove the responsibility back on you because you were outside of your area of responsibility. You were doing things that you were not supposed to do, not authorized to do. They were not part of your assigned duties. You're responsible. And at that point, they can make that case that it all falls on you. They have no responsibility. You need to understand the two. You will probably start out here. Be careful. Okay? They can probably put something back on you if something happens. But as you move up, you become that respondent superior. So make sure that your people are doing what they're supposed to do on that. Understand those things. Okay? Assumption of risk. We've kind of touched around the edges of that. There are risks involved in strength and conditioning programs and working with equipment and so forth, so there's risk involved with that. The client, the individual that you're working with, the individual that's coming to your facility for a workout, whatever, they need to understand that there's risk involved. And it's expected that they will assume some risk. But the risks that they assume are reasonable risk, not unreasonable risk. Those unreasonable risks can often be attached to unsafe environments. So if you have a safe environment and you do everything the way it's supposed to be done, you're probably gonna be in pretty good shape. But if you don't have a safe one, things aren't going the way they should, you may have some issues with that. How much time do I have, Dr.
About
Green?
5 minutes, yeah.
About 5 minutes? Let me see if I can pull up a couple of things. Let's do attractive nuisance, and I'll stop there. I have some, this is something else that you might need to be familiar with. There are, again, look at my spacing messed up. There are 4 elements to an attractive nuisance. Now, listen carefully to these. Number 1, the owner of the property had knowledge or should have had knowledge of the conditions of his or her property, okay? Number 2, children are attracted to the property, or it is foreseeable that children would be attracted to the property. 3, features of the property would be perceived as being inherently dangerous to children by the average adult person. And 4, the owner of the property failed to exercise reasonable care to protect the children. What is the key person in that? Children. So when we talk about attractive nuisance, we're not talking about adults. There's a rule of thumb that can give you some idea of what to expect of individuals in different age groups. It's just a rule of thumb. It's not a legal doctrine. You're not going to hear it in court, but what can you expect if you're dealing with children? Children usually, under the age of 7, they're not expected to understand danger, okay? Between the ages of 7 and 14, they're getting to the point where they can be expected to understand danger and try to take some precautions against danger. But not all children develop at the same level. After the age of 14, that expectation increases that they can understand danger and try to avoid and appreciate danger, okay? So we're dealing with children here. Will you have children? Could you have children associated with your facility? What if a mother or father wants to come to your facility and work out and they want to bring their kids? How are you going to handle that? What's your policy on bringing children to the gym? How are you going to handle that? If you allow it, how are you going to handle those children around equipment? Mike Tyson's 4-year-old daughter died from an accident on a treadmill. That's terrible. It's terrible. My question is, what was his 4-year-old daughter doing on a treadmill? I've known adults that don't understand a treadmill, can't get off and on a treadmill without falling. Okay? But we're dealing with children. First thing is, you're responsible for knowing about your facility. Okay? You know that there are things there that would be attractive to children. And children like to go and play. They're going to try things out. They're going to grab those weights. They grab a 50-pound plate, try to move it. They can't move it, but they're going to do something with it. They want to lift the bars. They want to pull the cables on the machines. They want to pull the pins. They want to play with the treadmill. They're going to try things that's attractive to them. Okay? You know that. A reasonable person would know that. Second thing is, you didn't, or the next thing is you didn't do anything about it. Child is injured. That constitutes an attractive nuisance. What you deal with, if someone is a child and child is injured, it could be considered an attractive nuisance and you can be held responsible for that. I have some other things I wanted to share with you here. Questions? Do you have any questions? Anything that you want to share? Any points that you want to make? Anything?
I covered a lot.
It did. We should have had 2 or 3 weeks on this probably to dig deep in and bring some specific examples in. They're out there. The point, guys, is this. When we look at policies and procedures, why do you have policies? If there's no reason for having a policy, why have it? But if you need a policy, get a policy in place and come up with procedures that will allow you to implement and enforce that policy. And you do that to protect yourself and to protect others. And then we can break that down, and what I chose to do was look at the legal aspects of this and some of the things that can result from not having good policies in place, not having procedures in place within your facilities. Anything. Now, after you guys leave today, Dr. Briggs and I are gonna talk about this, and if he was reasonably satisfied with what I gave you today, he might ask me to come back Thursday, so I would ask you to do this. Between now and Thursday, think about what I presented to you today. See if you have questions, and what I will do, if I come back on Thursday, what I will do on Thursday is I'll open the class by asking you, do you have any questions or comments or concerns about what we did today? So if you think of anything between now and then, jot it down, bring it back, and we'll try to do something with it next time. Fair enough? Guys, take care of yourselves. Dr. Briggs, anything for?
Yeah, no, that's good. I was the director of the Albany Y for a few years, so when we do the question and answer Thursday, I might bring a couple things into that. Because we had a youth policy that I thought